Thank you everyone for joining. We're thrilled that you are with us today. We're very excited to present on this topic. This is one of our crossover panels when we get to don both our safety lawyer hats and our employment lawyer hats. Today I am joined by our newest member of our California team. I'm thrilled to introduce Ms. Kimberly Cole. She will be playing the role of employment lawyer, which she does every day and has for the last few decades. I'll let her introduce herself a little bit more in a few minutes, but just really thrilled to be presenting this webinar with you today. And we are going to be discussing how safety impacts the workplace beyond OSHA. So we're going to talk about a number of topics and how kind of our worlds collide within our firm. As you know, we have a dual practice at Conn Maciel Carey. So we cover both of these topics day in and day out, and are excited to kind of give some more insight into how these things work together. I'm Megan Shaked. I am a partner out in California. I'm housed out of our NorCal office. I've been with the firm for a number of years, and I practice both on our employment side, doing advice and counsel and litigation, as well as on our OSHA side, doing primarily Cal OSHA, but advising employers on OSHA compliance, handling inspections and appeals, and all of that good stuff.
Hi, I'm Kim Cole. I'm new to the firm, but not new to employment law. I've been practicing for now, I think this is my 25th year, and I love it. I do pretty much all aspects of it, from FEHA discrimination complaints and that sort to wage and hour investigations, leave, whatever issue presents. I'm a certified workplace investigator, and I'm super happy to join Conn Maciel.
Thanks, Kim. All right, so here, as promised, our full agenda for the day, for the next hour. We'll spend a little bit of time kind of setting the stage and giving a little bit of context for our discussion. We realize some folks may be joining who have more familiarity and comfort on the employment side versus the safety side. So we'll just make sure that everyone kind of understands where we are. And then we'll get into some of the topics that where we see most frequently. It's not an exhaustive list by any means, but the areas where we see safety and employment colliding most often. So we're going to talk about work-related injuries and illnesses. We'll talk about some common wage and hour issues that come up in this space. We'll discuss whistleblower anti-retaliation protections. We'll talk a little bit about unfair competition, and then we will close out with some tips around employee discipline. And we will send you all on your way unless you have further questions. We will do our best to answer questions as we go along. I'll try to keep an eye on the chat on my other screen, but if we miss anything or you want to interface with us individually, feel free to reach out. We're happy to chat with anyone. All right, so what are we talking about here? When we talk about kind of how safety and employment work together, one thing we want you to keep in mind is who is at the table, who is part of these discussions, who is involved, and who may need to be pulled in at a later date. And we're going to give an example in a few minutes using the workplace violence prevention law, which hopefully you're all familiar with and went into effect last year, to kind of think through who may need to be involved when we're talking about an issue. Are we talking about a safety team or a risk team or a compliance team? Are we talking about a human resources team or people managing folks? Are we talking about operations? Are we talking about supervisors? Are we talking about, other folks that we might not even think off the top of our heads, like folks processing insurance claims or other third-party administrators who might be assisting with handling your leaves of absences, who might get an update about something that needs to be considered. So thinking through the universe of folks who might need a seat at the table, and then what's going to trigger getting them involved so that you make sure that the folks who need to have eyes on an issue are pulled in at the necessary times. Kim, maybe you can offer a little bit of insight from the employment law side on kind of how the ways in which we're talking about kind of managing both our safety compliance and our employment law compliance.
One of the things that you'll hear Megan and I talk about repeatedly is the importance for communication and clear policies. So when we talk about compliance, we want to make sure that we have the appropriate policies in place that are clearly documented and available to the employees, and that we have the appropriate trainings for them. So in that way, we're managing the expectations of the employees and supervisors and managers, so everyone knows what to do when situations arise. Through this, like through coming today, we learn about training, training for our employees, training for, each employer. It's always so important. And another thing that you'll hear Megan and I repeat today is that one of the things that we see repeatedly is that employees will use these sort of complaints or issues that come up to maybe communicate their discontent over an issue. So that's something else that we're going to emphasize today. One of the things that go hand in hand as well are enforcement and investigations. When an issue arises, please take note of it. Literally take note of it, and bring it into the mind of the correct person so that we can address these. This will not only allow to consistent enforcement, meaning that it's applied the same to each employee, but also that if it needs to get to us or it needs to go to an appropriate government agency, we have the documentation we need to defend the best that we can for each situation that arises. And one of the things that I see a lot, I'm sure Megan sees a lot, is a follow through with either the complaining person or the government agency, is to make sure that they are being communicated with regarding what the issues may be, that it's been handled, that you have the documentation, and any of these things. And these things that Megan and I will, again, you'll hear us repeat it throughout the training today.
Yeah, absolutely. And when I think about these issues of how do we manage this from a safety standpoint, there's a couple things that kind of rise to the surface for me. One is making sure, and this it goes to compliance and expectations and training and communication, is that folks really know what to do to work safely. And you'll see it in a slide later on, and we emphasize this with clients all the time, that at least when we're talking about OSHA, though it applies on the employment side too, if it's not written down somewhere, OSHA isn't convinced that it happened. So making sure that things are in writing, making sure that things are being communicated correctly is really, really key. And then if there is an incident or an issue or a concern of any kind, that is appropriately addressed. So that if there is, a real or even just perceived gap in safety or other aspect of compliance, that the employees have the confidence that it's being handled and that the workplace is being returned to a safe and compliant workplace. And this is the part where the lawyers highlight all of the scary things that happen when this is not managed correctly. So, Kim, again, on the employment side, kind of what are we managing when we're trying to, keep these all of these concepts up in the air at the same time?
I mean, what we're managing in general is employee contentness at work versus discontent, which can then manifest in several ways, as you all know. I mean, it can manifest into them seeking advice of a lawyer and then addressing whatever complaint may come up. We might receive a demand letter from that. It can go to a complaint and to agencies that are taking on a larger role in managing things like wage and hour disputes, or the Civil Rights Division has separate independent investigators now addressing what they view as retaliation complaints, or as we know through COVID-19, they had a completely separate division addressing whether or not COVID-19 leave was being handled appropriately. And then on a larger, what's occupied almost the last decade of my career is dealing with class actions and PAGA claims. And what Megan and I have been discussing recently is when some of these lack of compliance of not following some of these policies, let's say, for example, the workplace prevention policy becomes an underlying PAGA claim. So not following through at on the onset of getting your policies in place and the proper trainings and reporting can lead to these other larger pieces of litigation or investigations by government agencies outside of OSHA.
Yep, that's exactly right. We see concerns that employees have maybe crossing over issues. Sometimes, we might get an individual demand letter or a lawsuit that's complaining about not only wage and hour issues, right? I wasn't paid properly, but also maybe a retaliation claim based on workplace safety. I complained about the, safety and health at the workplace, and the next thing I know, I was disciplined or I was demoted or I was terminated. I had an adverse impact, and it's because I complained about OSHA compliance. We also see it used, and Kim referenced this earlier, if a group of employees are dissatisfied, maybe about an employment issue or a workplace safety issue or about something else. Maybe they're unhappy with their manager, or maybe they're unhappy about some other aspect. They know that some of these tools exist as a way to get attention for the issue that they're really having. If they feel like they're not being heard, maybe that pushes them to turn to the labor commissioner for a wage and hour issue, or turn to Cal OSHA for a safety issue, or turn to plaintiff's counsel to say, what do I do? I just lost my job, or I think I'm going to lose my job and I want some recourse. So these are the sorts of things, we want to keep in mind, but we also want to keep in mind all of the amazing benefits that come from managing this well, which is, an efficient, productive, happy workforce with people, staying and continuing to build their experience and the institutional memory of a workplace. And that those sorts of like high morale outcomes are the really positive side of things that come from managing this well. Another note, obviously, for unionized workforces or for workforces that may become unionized, that labor union and employee relation issue can be a really big part. Employee relations, obviously, a huge issue, regardless of union status of a workplace. Okay, so we want to give you a kind of a more concrete example, a way to think about this. And workplace violence prevention is a really easy way to think about this because these sorts of issues come up all the time. So California legislature passed a bill a couple of years ago that put in a requirement under the labor code to have workplace violence prevention in most work sites in California. There are some exceptions. And this is a massive law, lots of compliance components to it. But I just wanted to highlight, based on the requirements of the written plan alone, how you can see all sorts of issues across employment and safety are implicated by just one section of the labor code. So the first is that the plan has to identify the names or titles of the person responsible for the plan. So this starts to ask questions like, well, who's going to be responsible? Who's going to own this part of the plan? Is it going to be safety? Is it going to be HR? Is it going to be a site manager? Is it going to be somebody else? There's also a specific requirement for having effective procedures to obtain the active involvement of employees in unions. So this is a recognition that employee relations is a huge part from the legislature's perspective, that employee relationships, employee involvement, employee feedback is in their mind critical to the effectiveness of this prevention program. There's also a recognition, not just amongst your own employees, but about any other employer or workers who might be on your site, that you have to coordinate with them. So that might implicate, if you're working really closely on the ground with another worker who works for another employer, That might be an operations issue, or it might be a contractual issue, making sure that your contractual arrangement with any other employer on the work site addresses compliance with OSHA requirements. Another requirement is, we see this a lot, we see specific anti-retaliation provisions in lots of laws individually within the law. There are some larger anti-retaliation protections, which Kim will talk about a little bit later, but this one has a specific one in this law, and it's not unusual in that sense, that there have to be effective procedures to accept and respond to reports of workplace violence and to prohibit retaliation against employees who make such reports. Moving on, we have procedures to ensure supervisory and non-supervisory employees comply with the plan. So this kind of implicates potentially disciplining employees who do not comply with the plan. And who's going to be responsible for that, and how is that going to work and not run afoul of collective bargaining agreements or your employee handbook or your safety compliance requirements. Moving on to the next slide, we'll go through just a couple more I want to highlight. Procedures to develop and provide training. So this is, again, where we see the importance of not only training, not only communicating the expectations to employees, but ensuring that it's effective, so that if a workplace violence incident arises, employees really know what to do in an incident. We see all the time where an employee may have a compliant policy, may have an amazing program on paper, but you also want to make sure that the employees are going to kick into action if they need to actually use that policy, if they actually need to use their training and they know what to do. So the effectiveness of that training and communication becomes a huge part of compliance. Let's see if there's any other way we addressed kind of the follow through of these programs. It's not just enough to identify issues. You also have to make sure you've addressed them. So procedures to correct workplace violence hazards identified and evaluated and implemented. So this is just one kind of example to give you to see how all sorts of aspects of an employer's workplace can be implicated by a requirement like this. We often get the question of, we pose the question, this sometimes seems like a security issue or a safety issue, but you really have to have HR involved in the workplace violence prevention program as well. So we also love to include this slide because, again, the workplace violence prevention law is a really good example of the intersection of so many different laws. So you can imagine an incident where if folks are injured or they have a stress response post-injury, you may have claims to workers' compensation. There are numerous privacy concerns that are specifically addressed in the law and need to be kept in mind. Maintaining confidentiality of medical information and maintaining privacy of individuals who might have been involved in an incident or participated in an investigation, to make sure you're not creating another risky situation for employees down the line. The Americans with Disabilities Act or other related state laws may be implicated if there's a disability involved. Discrimination issues come up a lot when there is an actual or even just perceived concern by employees that rules are being enforced against certain people and not enforced against others. So that consistency of enforcement that Kim mentioned is critical. Starting to kind of veer a little bit out of our wheelhouse, you get third-party kind of risk concerns of premises liability, potential suits by third party, kind of going outside of the employment or other worker situation. But that again may mean that you have to bring folks from other teams in to review a plan or an incident to make sure that everything that the employer is concerned about and needs to have eyes on is happening. We'll talk more about reasonable accommodations for disabilities, but also good reminder that there are lots of leave protections that are very, very, very specific. For example, victims of crime, domestic violence victims, there are specific requirements in the law. And so that's something kind of to know in the back of your mind if that's ever implicated in an incident to make sure you're complying with that. Um, there are allowances for temporary restraining orders that can be obtained by individuals, but also on behalf of, by the employer on behalf of its employees. And there can also be additional implications when employers have search requirements. They might be physically searching bags, or they may be searching, emails and other electronic records, or even going out to do public record searches. So making sure we're complying with restrictions that are placed on employers for things like that are also very important. Okay, we're going to transition to one of our first topics, which is work-related injuries and reporting requirements. I always highlight the fact that in California, the requirements to report serious injury or illness or a death are a little bit different than outside of California. So if you have folks who are managing reporting outside of California, you have to make sure they understand the nuance of the California requirements. So the reporting requirements show up in two Cal OSHA regulations, 342 and then 330. So you have to report within 8 hours in California, which is a very short period of time, shorter than outside of California. And although there is an exception for a longer 24-hour period, if an employer can demonstrate exigent circumstances, it's an incredibly high bar. So the 8-hour window is really what we're looking at. And putting fatality aside, that one's less complicated. Serious injury or illness is specifically defined in the OSHA regulations, and it includes any injury or illness not only occurring in a place of employment or in connection with employment that requires inpatient hospitalization for other than medical observation or diagnostic testing, which is a highly litigated area. So you can seek support from counsel when making a determination about whether something is reportable or not, or where an employee suffers an amputation, loss of an eye, or any serious degree of permanent disfigurement. There is an exception for injuries caused by an accident on a public street, unless the accident occurred in a construction zone. So if you're talking about like a traffic accident, even if it was involving employees, there's an exception for that in the regulations. An employer, because there's California doesn't have a cutoff of, you may be familiar with a 24-hour cutoff period. That doesn't exist in California. So employers really have an obligation to exercise reasonable diligence to follow up on the progress of an employee's injury to see if perhaps it didn't appear reportable at first, but if it does become reportable at a later point, that obligation to report remains. There's very clear precedent in with the appeals board that doubts about whether to report should be resolved in favor of reporting. So really recommend seeking counsel advice from counsel if there's any sort of gray area or question about whether something's reportable. And another thing to note here again is if you have a mechanism for serious injuries or illnesses to be reported to certain people to do that evaluation of whether something needs to be reported, it's good to think through who those people are, who may be receiving the information about a serious injury or illness, and are those people also aware of who to share that information with so that the reporting requirements can be complied with. For example, if there's somebody who, an injury might, if an injury happens and somebody's responsible for following up with the condition of the employee, do they know, I have to notify, for example, safety if there's an update to their condition? or if they're getting information from outside of the employer, are they thinking through how to consider that information and who needs to be provided with that information? So, Kim, when we have a workplace injury or illness, what are the sorts of California employment laws that we should be thinking about for compliance? Because it's not enough just to be thinking about this on the safety side.
Right. So, I mean, California has developed several different means by which an employee can have time off and can have some coverage during that time. And one of the obvious is workers' compensation. If it's a work-related injury, then it moves into that category. At the same time, though, it's always important to remember the very generous sick leave that California provides and that it's an absolute requirement. I'm sure that everyone remembers that we're not supposed to just look at the general California law, which is now for full-time employees 24 hours or 3 days. But there's also local ordinances. I was taking a look today to remember, like Santa Monica and Berkeley, they have 72 hours if more than 25 employees, and then 48 if less than. Los Angeles has 6 days or 48 hours. And San Francisco, where Megan and I are housed out of, it's 72 hours if more than 10 people, 40 hours if less than 10 employees. So we have a very generous sick leave. On the employment hat, um, I always want to remind the sorry, Megan and I were just chatting. Always want to remind that we have an absolute requirement on the wage statement that it needs to be accrued and demonstrated on what is taken. So one of the first thing plaintiffs' lawyers will look at is your wage statement, and that they are looking for that specifically because it's an absolute requirement. An interesting question I've been getting lately is whether or not employers have to pay that out on termination, and you do not. That is not a benefit that needs to be paid out like vacation if you are fortunate enough to be able to have a vacation policy. So it's really important that you have that you keep that on your wage statement. And if you have any questions at all about what's appropriate to be on your wage statement, please let us know. Do you want me to keep going? I'll go to the different leaves of absence that are available. One of the things that there are several means that are available for let me cover state disability leave, which is something that also covers income protection for employees. You should have something in your workplace, in your break room, that allows the employee to know about this benefit, or you provide it when they're hired. But that will allow them to know that they can go to the state, and if they receive the appropriate medical certification, that they can receive some income protection from the state of California. I believe up to 52 weeks is what they're able to have. And in addition, we have different leave laws, like Megan mentioned earlier. If there's victims of domestic violence that qualify, there's leave laws protection for that. We have the FMLA with the California CFRA protection, and that can go on for a series of weeks. And again, that doesn't have to be taken at one time. It can be taken intermittently, depending on what is needed, and also what a doctor's note may provide as well. And company policies, whichever company policy is clear and written and provided to the employees. And as we discussed earlier, is applied to everyone. If you do to one, we do to all, is what we like to say. So if that's something that if you have a company policy relating to leaves of absence, please make sure to update your policy to make it clear and available to your employees, and make that available. As noted, there are times that there might be multiple leaves that apply to one employee. So we want to make sure that we are clear with the employee that we're documenting what we're doing and that they are given all of the opportunities to not only have the time off they need to heal, but also that they're given whatever ability to cover compensation that they are able to achieve. And there are times even that employees who have a reduction in hours, once they're done with their disability leave, can actually have an unemployment leave for a reduction in hours as well. So even though they don't have to be technically terminated, if there's some reduction, they can apply for that benefit as well. So, Megan, am I forgetting any of those?
No, that's great.
Okay.
So we talked about kind of when an employee might need to be paid for time off, might have benefits, disability benefits for time off, or workers' compensation benefits from time off, and might have protected leave from work. But what about when we're talking about getting an employee back to work? What sort of requirements should we be thinking about then?
So this is super important. I would say one of the larger base of claims that I look at are whether or not the employer engaged in what we call the interactive process. I think most people have heard of the interactive process at this point. One of the things to remember that is there are no magic words that trigger this necessarily. It's new or should have known. So if you know that your employee's been injured, if you know that they're coming back to work, or they haven't officially left work, it's on HR, the manager, the supervisor, whomever is engaging to have a discussion with the employee and find out what is happening. In that vein, please take notes. Please, document the conversation, and also feel free to ask for medical certification. If a reasonable accommodation is required, that information comes from the doctor, and then you receive it and see, are you able to accommodate that within your business necessities? There are times I've helped negotiate when the employer's not able to. Let's say you're a security guard that has to travel around the perimeter all night, but you're now required to sit for the duration of your entire shift. So there are things that we need to look at. Is there another position? Is there something else we can do? And before we say to this employee, we don't have anything available. But that's the interactive process. And it is not a short process. It can go on. And again, the most important thing we can tell you is to document this and reach out to counsel if you have any question about it, because not interacting alone is a cause of action underneath California law. And we want to make sure we cover you in that regard and give you all the appropriate words and tools and information you may need to make that happen.
Couple
Yeah.
more nuggets that we see employers sometimes tripping over
Mm.
are what if somebody, let's say California Family Rights Act leave, CFRA leave, or FMLA is exhausted, and all of their sick leave is gone, and they've taken all of their protected time off. What does that mean in terms of next steps for an employee?
Sure. So California law, as we all know, is very expansive. So it's, employees have several rights, and one of these is under case law and under the law, it's been proven that just giving an extended leave is an additional accommodation that can protect an employee and protect the employer from a right of action. We understand that you have a business that you need to run. So that's one of the reasons why we want to make sure that we're engaging and we're providing every leave of absence that we can. But sometimes extending the leave alone is an accommodation that we need to consider. And to Megan's point, the California law is very expansive on many things. The definition of disability, I was talking about earlier how I had a case early on where heartburn was the disability that needed to be accommodated. California is very protective of its employees, as we all know. And so we want to make sure that we really consider what the employee is bringing to you as their concern, their complaint, and anything, so that we look at it, because the likelihood that California protects it is a high chance.
Great, thanks, Kim. And one other note before we move on to the next topic for sick leave, there's been a lot of expansion and leaves of absences. There's been a lot of expansion over the last few years for certain very, very nuanced requirements and leave
Mhm.
requirements. So it's a good time to review handbook, making sure your policies and procedures are up to date, as well as with sick leave. There was an expansion. We kind of had this number in our head of 24 hours, 3 days.
Right.
That was expanded to 40 hours, 5 days recently. So, it's always something that has to be revisited in California, given the constant changes. Next, we'll get into a little bit of wage and hour issues, moving on
Yeah.
from kind of leaves of absences, reasonable accommodation, interactive process. We want to talk
Everybody's
about
favorite.
rest, right?
Right.
We could spend a whole hour talking
Uh,
about that issue alone.
Hours. Yes.
Um, so feel free to make your request for our webinar series for next year, while we're still earlier in the year. So next we want to talk about rest breaks because we often see rest breaks addressed in a handbook on the wage and hour side,
Mhm.
and then we have rest breaks on safety side for heat illness prevention. So if you want to give us a little breakdown of how the rest breaks work on
Sure.
this is kind of not the best way to articulate it, but we'll call them the wage and hour rest break for this purpose.
Sure. Okay. So as we all know, meal breaks, are required. You are required to, unless there's an exception to this, but we're required to make sure that our employees take their 30-minute uninterrupted break. Rest breaks are different. Rest breaks, we just need to provide the opportunity. We don't necessarily need to document those. And so that is every a 10-minute break, up to 4 hours. There are calculations, but up to 4 hours for every 4 hours worked or a fraction of it as written on the slide. Yes, it's ideally in the middle of the 4 hour period. We don't combine it with lunch and it's duty free. I know there are several cases recently about whether or not someone has their radio on. That's not duty free. It needs to be uninterrupted. If they don't have an uninterrupted duty-free rest period, then they're supposed to be provided 1 hour of premium penalty, 1 hour of their pay. What I would say, because employers are doing such a good job at monitoring their meal breaks, that one of the things that plaintiffs lawyers are looking at, they'll flip to the wage statements to see if there's any premium pay for a rest period. And then if the employee is telling them that we were too busy, I wasn't able to take a break, whatever the work is, let's say it was, working in a factory setting and, they weren't able to, or they had a rush job. So if they look and say that there's never been 1 hour of premium paid for a rest period missed, then that's becoming the basis of class actions and even PAGA litigation. So I would say to be very cognizant of keeping track. If an employee tells you that they've been unable to take a rest break, I would even encourage you to periodically address your supervisors to determine, are there days that you've been too busy to take your rest break, and contemplate paying a period penalty for that missed period so that we can get on top of defending against that type of claim.
Perfect.
That's the
Thank you so
my
much. So
yeah.
we'll contrast that with the heat illness prevention breaks, which there's specific requirements for outdoor workers and then specific requirements for indoor workers. But generally, you have to allow and encourage employees to take preventative cool down rest when they feel the need to do so to protect themselves from overheating. So this isn't tied to the schedule like the ones we just discussed, where it's, 10 minutes every, so many hours. This is really tied to the need that an employee feels to protect themselves from overheating. And unlike a um, duty free, you can't really be monitored, you can't really be told what to do, you can't be required to remain on the premises. It's completely duty free. Here, the employer actually has an affirmative obligation for an employee taking a cool down rest break to monitor them, ask them if they're experiencing any symptoms of heat illness, encourage them to stay in their rest as long as they need it, and not order them back until any signs or symptoms, if they're experiencing them, have abated, no less than 5 minutes plus the time it takes to access the break area. Then there are some requirements under high heat conditions, particularly for agriculture, where there is a set schedule for heat illness prevention rest breaks, which are a minimum of 10 minutes every 2 hours. Now, they can be concurrent with meal or rest breaks if it works out, because all of these rest breaks, well, not the meal breaks, but the rest breaks on both sides of the issue are paid. But the practical reality is it might not always work out that way. Somebody might need, a couple of breaks in the tail end of their shift if it's the warmest part of the day and they're starting to feel the impacts of working in the heat. Also presents a lot of challenges if you're ever in a circumstance where you need to work with employees on perceived abuse of the rest break policies. This can be incredibly challenging given the language in the heat illness prevention regulations, which again is based on the employee feeling the need to do so to protect themselves from overheating. Also, if you have an employee combining their wage and hour rest break, where they're duty free, can't be told what to do, and their heat illness break where they have to be monitored, that can also present some challenges that employers should be aware of. Okay, I'm going to go through the warehouse quota issue just really briefly. This is kind of an old issue. If it impacts your operations, I'm happy to answer any questions about it. But a few years ago, there was a new law that was implemented for protections where employees are subject to warehouse quotas. And it's essentially a very, very direct call by the legislature to say, hey, if you're going to have incentive systems for employees to work harder, faster, more, you need to make sure it's not impacting their ability to comply with the law, to take their meal and rest breaks, to take their bathroom breaks, to take their heat illness prevention cool down breaks. And so there's really a recognition from California legislature of these crossover issues that we're talking about right now, because you see them in this warehouse quota law and you see them in the workplace violence prevention law, which came a few years after this one. So these are in there for your reference, but we don't need to spend too much time. We also wanted to highlight that California, the Department of Industrial Relations, under which the Labor Commissioner is housed, OSHA is housed, have specific kind of joint task forces to address, in this case, they have a task force, the Labor Enforcement Task Force, specifically designed to combat the underground economy. And they work with a number of agencies, including Cal OSHA, the Unemployment Development Department, the Contractor State Licensing Board, and numerous others to make sure that employers are complying with what they have to comply with. So what this might look like is something that starts off looking very much like a Cal OSHA inspection, but is being done in coordination with other agencies. And when you receive your request for documentation, you might not only receive a request for your heat illness prevention plan, your injury and illness prevention plan, your workplace violence prevention plan, your training documents. You might also receive a request for wage statements and other records of pay to make sure that employees are properly being paid under California Labor Code requirements. All right, we are going to move on to the next topic, which is whistleblower protections, anti-retaliation protections, and how do we manage those issues? Because it's often, we often see employees after there's a concern, after there's a dispute, after there's a termination, making a claim that, whatever action was taken against me was in response to me engaging in protected activity. So Kim, why don't you take it away?
Sure. I think similar, something I'm sure we're all aware of are the whistleblower laws that started with the requirement that the complaint be made to a government agency and now has expanded greatly, so that it can be not just in making a complaint internally, it can be made to a government agency, it can be, refusal to participate in an activity, it can be, it can be very broadly construed. So again, that's one of the reasons why we encourage good communication. One of the examples we also give is participating in an investigation. You have a government agency who comes in, or you have, your HR is doing an investigation, and people participate and, find themselves in the crosshairs of someone, a manager or a supervisor. So we want to make sure, again, that, we're properly participating, we're properly training, and we're, listening to the employees to the extent that we can. There is a requirement that these reports need to be made in good faith and based on a reasonable belief. Again, that's something that we determine down the line. So it's more helpful, at the beginning, at the onset, that we have good communication with your employees so that they're not reaching out to these agencies or making these complaints. And then bringing a whistleblower claim later on. As Megan mentioned, I don't know if you want to go forward to the next slide, that one of the things that we're seeing is that these whistleblower complaints are, there's a lot of things that they're able to bring up now. For example, harassment and discrimination is one. Again, being intimidated to not do something or to do something in the workplace is another one that we look at. Someone who receives disciplinary action for something that they don't perceive to be fair or even properly communicated is another one that we see them complaining about. And then something that's been coming up is whether or not there's a change in duties. And this, as you know, can come up for a variety of reasons. Maybe someone isn't doing as well, or they need to be changed based upon your business necessity, but they're seeing it as retaliatory for complaining or not participating again in an investigation. So, these are all a basis that we see when we're looking at potential whistleblower or retaliation claims that come up quite a bit. It's not uncommon when someone has a disciplinary action taken against them, and then they perceive it to be, a basis for retaliation or, again, a whistleblower complaint. Right. Megan, do you have anything? Okay. So one of the things that we've seen in my employer hat that we've seen more activity in are, like we mentioned at the onset, are the subsets in the California Rights Department, where they have investigators who are looking into what we view as kind of smaller claims. Generally, they're less than $10,000, but they are based on retaliation, or they're based on, again, the COVID-19, whether or not the leave of absence was applied properly. The retaliation complaints that we see can be based on the litany of issues we just discussed, whether or not it's an injury and then they were laid off from work, whether or not, improper termination, harassment, discrimination. And what happens then is it's similar to a demand letter. We receive information from the California Rights Department investigator. They want to see a host of records. They want to see, even I would argue, beyond the complaint itself. They may get into, your licensing, your registration with the state. They have the right to ask for several items, and then your policies, your wage and hour records, all of these things, which of course then can go into a larger issue because they often work in connection with the labor commissioner's office, and those issues can be then a subsequent complaint. It's not uncommon also to receive a complaint from the labor commissioner and the California Rights Department from the same employee who's frustrated and then is seeking some relief because they felt they were unfairly terminated, or they had their job position changed, or for whatever reason. So we are seeing a lot more activity from these departments in the government on trying to provide resolution for employees outside of, plaintiff's attorney or litigation piece. Then, of course, we get into litigation, which is, where we spend the majority of our time is defending employers against these claims when a case has been filed, and, we're off to the races on, talking to you about where your records and, fighting with opposing counsel to try to reach a resolution for you.
Thanks, Kim.
Mhm.
So it may be familiar to you the idea that somebody could file a retaliation claim with the Civil Rights Department, or it might show up in a demand letter or a litigation matter. But there's also another tool that district attorneys have used in the past, and we want to just spend a few minutes just going over that. So if those of you who might be familiar with kind of wage and hour litigation, you may be familiar with most plaintiffs will put in a claim under California Business and Profession Code section 17200 for unfair business practices. And that is essentially based on the idea that the allegation is that the employer did not comply with California wage and hour law, right? It didn't pay minimum wage or pay overtime or pay wages on time or give meal and rest breaks. And so it's unfairly competing against its competitors that are, at least in theory, supposed to be following these wage and hour requirements. So this same concept has been applied in the context of health and safety. So we've seen California Attorney General, local district attorneys, and even individuals acting in the public interest bringing a similar claim that because my employer is not following health and safety requirements, they are taking advantage by not complying. And so, we always think about this in terms of how might this be used by an individual or in a class action or a representative action under PAGA, because PAGA actions are based on violations in the labor code, and the health and safety Cal OSHA requirements stem from requirements in the labor code. That's where even if there's a Cal OSHA regulation under Title 8, the California Code of Regulations, they stem from a California Labor Code statutory requirement. So just to give you the big example of this is a case that was decided by the California Supreme Court in 2018, Solus Industry Innovations. Here, a local district attorney brought an action against the employer for civil penalties under 17200 and the Fair Advertising Law, which is under 17500, alleging employer violated workplace safety standards established by the Cal OSHA Act. The decision, it's very legally based, but they basically said there's no federal preemption because you have a state plan that was approved by federal OSHA, essentially. So what happened here is that a water heater exploded and there were 2 employees who were killed. Cal OSHA investigated and alleged that the explosion was caused by a failed safety valve and other lack of suitable safety features. So the Bureau of Investigation, which is a unit within Cal OSHA that is obligated again by statute to investigate fatalities and other serious injury incidents, they don't have an obligation to refer to the DA, but when they find evidence of criminal negligence, they can refer to the DA. The DA here filed criminal charges against the plant manager and the maintenance supervisor for felony violations of labor code, and then alleged 2 claims. One, that the employer's failure to comply with the workplace safety standards, which was based on the Cal OSHA investigation, amounted to unlawful, unfair, fraudulent business practices. And 2, that they made numerous false and misleading representations about that the employer made false and misleading representations about its commitment to workplace safety and its compliance with workplace safety standards. And as a result of those misleading claims, that there were violations. And they asked for civil penalties for each of the 2 claims of $2,500 per day per employee for a period of nearly a year and a half. So massive liability. So lots of tools in individuals and agencies' tool belt to kind of combat issues that they see. So lots of motivation for many, many reasons for employers to get this right. We'll round out with one more topic and we'll take the time because I'm not seeing too many questions. I'm not seeing any questions in the chat. So we'll take our last few minutes to kind of talk about our last topic and then round out for the day. employee discipline is a really interesting issue because on the one hand, you have to do it. You have to do it consistently because of the reasons we began to talk about at the beginning. You have to have clear expectations. You have to communicate those clearly, enforce them consistently, and make sure that the compliance is happening. So, how do you manage that with also knowing in the back of your head that employees may perceive discipline as an adverse action, and how do you manage that? So the benefits of discipline, we talked about a lot of these, but just serving this mutual goal of of valuing our team and reinforcing our policies and expectations, providing an opportunity for people to improve and grow. And maybe there was a misunderstanding or a gap in understanding of the expectation, and giving that opportunity for improvement, and increasing morale. And at the end of the day, having a happy, productive, compliant workplace. Of course, the pitfalls, like we discussed, are the, potential for discrimination if you're not enforcing the discipline consistently. And even if you are, managing the risk of an employee making a claim, even when it's not a legitimate claim. And that's where the documentation becomes really important, because you can have a way to respond to those allegations. We've talked about retaliation, harassment, sometimes discrimination, claims of discrimination, harassment, retaliation go hand in hand. And then, of course, making sure that if you have a collective bargaining agreement at your worksite, that there's compliance with employee discipline requirements for a unionized workforce. Also just wanted to, this is again getting a little bit into the legal weeds, but there are a couple of defenses available on the Cal OSHA side that have to do with employer knowledge, or the steps that an employer takes to do their due diligence in making sure that safety concerns are addressed, as well as defense for independent employee action, which is kind of employee misconduct. And both of those can rely very heavily on documentation of clear rules, clear expectations, enforcing the rules when there are violations, and having a process to discover if there are gaps in compliance. So not just implementing a policy and then walking away, I'm not seeing it, I'm not hearing it, I'm not doing anything about it. Really making sure, is it working on the ground? Is it being followed? Are there opportunities for improvement? Again, if it's not documented, response from Cal OSHA is often that we don't know that happened, or we don't know that the employee truly understood that. As we're kind of wrapping up, you can reference this employee discipline sheet, some tips on documentation, and an interesting exercise on employee incentives and whether that those are a good thing or a bad thing in a given circumstance. Do they create perverse incentives, or are they supportive of a safety program? So happy to answer any questions about those. But Kim, if you want to give us just maybe a minute or two of takeaways and wrap up, we'll send everybody on their way.
Sure. I mean, I think as Megan was just covering in the disciplinary process, but throughout, are the clear expectations that are set, not just with, well-drafted policies that are available, but, the demonstration and the training of your supervisors, your managers, and your employees. But one of the things that that I know you've heard us say over and over is communication. Communication demonstrates, like Megan was saying, are there gaps? Do we need more training? Is there a discontent? Is there a misunderstanding that we can thwart at the beginning, so you don't end up needing to necessarily call us and have us defend a litigation over, perceived injustice or perceived wrongs that we can handle in the workplace. As you know, I'm a certified workplace investigator, so I always will say a proper investigation is the most important thing. It does not have to necessarily be extensive. It's just taking in the information and seeing what next steps need to be done. And again, documenting, and by documenting the time, the date, name of the person that you spoke to. It's always so important, and it just needs to be housed in a place where we can find it if we need it later. And then again, consistent enforcement. If you do to one, you do to all. I know that Megan touched on this before about how we get a lot of discussions about people who are who people who perceive that their race or ethnicity or something is being treated differently. And so we want to make sure that it's consistent. One of the things that we offer here, especially in light of the PAGA changes and in OSHA that we're discussing, is audits. It's super important that we are making sure that your policies are correct, that your wage statements are correct, that we're properly handling those things. So again, we can thwart these challenges from the beginning. And again, document. Please keep track of everything is so important. I know that, workplaces, we don't love to write the negative or have those hard conversations, but we need to have them. So if someone's having performance issues, if they're not handling the workplace correctly or safely, that we know what's happening and that you document that, so that if it gets to a place where action needs to be taken, then, we have the ability to defend it when we need to, or when the government agency comes knocking, that they have the information that it was done.
Thanks, Kim.
Yeah.
So if anybody has any other questions, we'll circulate the slides and the recording in a couple of days. Here's the rest of our Cal OSHA webinar, and we have additional slides if you want to take a look when you have time, about our special offerings, as well as our blogs and our upcoming in-person Cal OSHA and California Labor and Employment Summit. It is our third annual event, so we look forward to seeing those of you who can attend in person. We'll be up in Berkeley on the Tuesday of that week and down in Pasadena on the Thursday of the week. Again, reach out if you have any questions at all, and we'll leave you with our contact information in case you don't have it. Thank you again so much to Kim and to all of you for joining today.
Bye. Thank you.